I'd like to talk a bit about the Canadian Constitution and the court system and the Supreme Court of Canada in particular. And I'm very much looking forward to your questions and your comments at the end. I'll get right into the first portion, which is me telling you a little bit about myself and the court system. As you know, I was appointed to the Supreme Court from British Columbia, so it's a special privilege to be able to participate in a British Columbia class, even though it is from this distance. I'm often asked how I became a judge, and I'm not quite sure what the answer is myself. But what I can tell you is a little bit about the route I took. I grew up in, or just outside of, a small town in southern Alberta, Pitcher Creek. Went to school, went to high school, as you did, and as you are doing, and then went to university. After having done a philosophy degree, I went into law studies. At that time, it wasn't very usual for women to go into law studies. Now our classes are 50% or more made up of women. But at the time, it was rather unusual. We were only a few women in our class. I chose law because it was something that interested me, and also because I felt that it would be a way to combine what I like doing, working with ideas and concepts, with actual hands-on contact with people, people's real problems, and working in the real world. And when I got into law, I realized that I had made the right choice, and I have been in that profession ever since. I was called to the bar in Alberta. I practiced there for 3.5 years. Then I practiced in British Columbia, mainly in Vancouver, with a large firm there. And I, in the course of those years, did a lot of different things, but mainly litigation law. After a time, I did a stint teaching as an associate professor at the University of British Columbia Law School, and I enjoyed that very much too. And when I was there in 1981, I was asked whether I would take a position on the trial bench in British Columbia. And I thought about it. I was quite young to become a judge. I was only 37. I know that doesn't sound young to you, but it did to me at the time. But in the end, I accepted it, and I have now been in the court system ever since, which is quite a long time, and it's been a wonderful, wonderful time. I served as a trial judge for 4 years or so, and then I was on the Court of Appeal in British Columbia for another 3 years. I was the Chief Justice of the Trial Division for a short time after that, before I was asked to come on the Supreme Court of Canada, which happened in the year 1989. So I actually moved through the system quite fast, which is astonishing to me, even looking back on it. Some people said I went through the court system faster than most cases. But I have been on the Supreme Court of Canada now for 18.5 years, and I've been 7 years as the Chief Justice. It is, and has been for all this time, a great honor and privilege to serve as a judge, and for the last 18 plus years to serve as a Justice of the Supreme Court of Canada, which is, as I'll be saying a little bit more about later, a challenging but fascinating role. That brings me to the role of the courts in Canadian government. How do the courts fit in with Parliament, with the legislatures, with the executive? This is something that a lot of people aren't very clear on, so I hope you'll bear with me if I just take a minute to outline what's the constitutional structure of the institutions of governance. The courts are an institution of governance, along with Parliament, legislatures, and the executive. Canada is a constitutional democracy, the power that anyone has, be it a prime minister or a judge or anyone else who's exercising public power, has to be consistent with the Constitution. And the Constitution divides Canadian government into three branches. The legislative branch, which is Parliament and the legislatures, is first. Second, the executive, which is the Prime Minister, the Premier of your province, and all the people who carry out those laws, and the judiciary. And each of these three branches is essential to a democracy, and each has separate and independent powers and areas of responsibility. The legislative branch, as I said, is composed of Parliament and the provincial legislatures, and it functions to make laws. And I'm sure you're all very familiar with that role. There are some limits on the legislative branch. First of all, they can only make laws within their jurisdiction. And as you know, the British North America Act in 1867 divided jurisdiction between the federal government and the provincial governments, Section 91 and 92. And so the province of British Columbia, for example, the legislature in the province of British Columbia has to, or any province, has to bring itself within Section 92, which is the powers that are given to the provinces under the Constitution. Similarly, the federal government has to bring itself within Section 91. The second limit is that the legislatures and Parliament have to comply with the Charter. Since 1982, when the Charter was adopted, all legislatures must comply with it, subject to the notwithstanding clause that can be invoked under special procedures. That's the first branch of government, the legislative. The second branch is the executive. As I mentioned, the Prime Minister, provincial premiers, ministers, government employees. And their role is to carry out the laws passed by Parliament and the provincial legislatures. The third branch of governance is the courts. The role of the courts is probably best described as consisting of three things, although these overlap. First of all, one of the main roles, the main role perhaps of the courts in ordinary day-to-day functioning is to decide disputes. The law governs virtually all aspects of our life, many aspects in any event, how we arrange our contracts, how we drive, how we have to conduct ourselves with respect to other people and not hurt them. If we do hurt them, we may have to pay damages. In the family law context, divorce and custody and payments for support, all of these are governed by the law. And of course, people get into disputes about these things, and they come to the courts for resolution of those disputes. So the main task of the court vis-a-vis the ordinary citizen is probably seen as deciding these disputes. They should be decided in a prompt, effective way. We work very hard to do so. Access to justice is, however, as I have said publicly, a concern. We would like things to be better in certain areas. We try to keep delays down. We try to keep costs down. The ideal is that every citizen should be able to access the court. The second function, which of course overlaps with the first one, is that the courts interpret the law. Parliament and the legislatures set out the law, and as you may know, there's also a body of common law that we inherited from England. And the courts interpret this law. And you might ask, well, why do you need to have somebody to interpret law? Isn't it plain on the books? If there's a law that Parliament has passed, where does interpretation come in? Well, the fact is that laws are passed using general words to deal with a huge variety of situations, and often disputes arise, questions arise about what does a particular word mean, or does this law apply to this situation, or how does the law apply to a new and emerging situation. So the law is constantly a growing and living thing, and it falls to the courts to interpret it. Our basic rule in interpreting laws passed by Parliament and the legislatures is that we try to interpret the law in a way that conforms to what Parliament or the legislatures intended. We look at the words, and that's the best indication of what Parliament and the legislatures intended, but sometimes the words aren't clear, and we have to look at context. Perhaps we'll go back and look at what was said when a law was adopted, and so on. The third function, and it's also related, is to rule on constitutionality. And this is the task of ruling on, in situations where there's an allegation that a branch of government, be it Parliament, the legislature, or the executive, has overstepped the bounds that are placed on that particular branch or function or person by the Constitution. And this is essential to a constitutional democracy. You have to have a referee, if you wish, to say you're in, you're out, make that kind of decision. And that's the kind of decision the courts do. And when they do it, of course, they aren't just deciding on government powers. Each time they decide such a question, they're deciding on individual rights, because the government power must be seen in relation to the individual that it affects. And so the courts define the scope of constitutional rights and freedoms. Well, that's what courts do. They decide disputes, they interpret the law, and they rule on constitutionality and individual rights. How do they do it? How are the Canadian courts organized? Let me describe them by the metaphor of a pyramid. At the base of the pyramid, you would have provincial courts. These are appointed by the provinces, and you have also trial courts in each province, the Supreme Court of British Columbia, for example, where I sat, which are appointed by the federal government. These are the basic trial courts, and this is where you go in the first instance. That means if you have a dispute, this is the first place you will go, and there will be a judge that will rule on it. For that reason, these courts are sometimes called courts of first instance. Next up on the pyramid are the provincial courts of appeal, and there is a federal court system for certain federal issues. There's a federal court of appeal as well. But these courts of appeal are very important in the structure. They decide whether the law has been correctly applied by the judges at first instance. Now, I have to make it clear that most cases never get appealed. Most cases are simply decided at first instance. The parties accept the decision. It appears, even if they don't like it, it appears to be a sound decision, and that's the end of the matter. But in some cases, a party may feel that the judge has misapplied the law or made some egregious mistake in the facts, and in those cases, a party can appeal to the appeal courts. And these courts will rule on whether the decision below is correct. Now, at the level of the provincial courts of appeal, where I sat for a number of years in British Columbia, about, I would say, 80% of the work is simply correction of errors. Nobody's arguing about what the law is. The law is clear. Everyone agrees on what the law is. The question is, did the judge apply it correctly? For example, in a sentencing case, is the judge's sentence too severe or not severe enough? Or did the judge misstate the rule that governed a contract dispute? That kind of question. And so the Court of Appeal is concerned to see whether in the application the judge applied the law, which everybody agrees on, correctly. But there are some cases, 10, 20%, I don't know exactly, but a small amount, where there are genuine issues of law that arise, or constitutionality. And, of course, constitutional questions are questions of law. And then courts of appeal have to involve themselves in the interpretation of the law and sometimes in issues of constitutional law. Now, at the Supreme Court of Canada, this is the highest court. If a party is dissatisfied with a decision from a court of appeal, they can attempt at least, and I'll say more about that later, to appeal to the Supreme Court of Canada. This is the last judicial resort for all litigants. Whether you win or lose at the Supreme Court of Canada, that's the end of the judicial road at least. You might go to Parliament and say, change the law, but as far as the courts go, that's it. We hear appeals in the Supreme Court of Canada from all the provinces and territories as well as from the federal court system. And there's no limit on our jurisdiction, unlike the United States, where the Supreme Court of the United States has federal jurisdiction. Our jurisdiction applies to every kind of case you could imagine: civil litigation, criminal cases, family law, constitutional law, business, administration, to name a few. However, there is another restriction that's very important, and that is that we hear only legal issues of public importance. So while theoretically any case could come before us, we are restricted to hearing issues of public importance. I'll return to, I mentioned the courts of appeal. 80% of their work is correction of errors, and perhaps 20 involves debates about the law or the Constitution. I would say it's reversed, or even more starkly reversed in the case of the Supreme Court of Canada. Almost every case that comes before us involves an important issue of law, because that's what we're there for. We're not here to correct errors. That's the job of the provincial courts of appeal. We are here to settle the law for Canada. Now, how do we sort out what cases we're going to hear, what cases are of public importance? We do it by mainly a leave procedure. You cannot, except for a few cases under the Criminal Code, come to the Supreme Court of Canada without leave. And there's another exception I have to mention, which is a reference by government, which I'll get to. But subject to those two exceptions, you have to apply for leave. This is usually done in writing, and documents are filed, and we look at these documents and determine whether the case raises an issue of public importance. We receive about 700 or 800 leave applications a year, and we grant approximately 10% of them. So you can see that a lot of people try to get here who don't get here in the end. I mentioned that there are two other ways to get to the court. One is if one of the governments, a provincial government or the federal government, refers an issue to the court for decision. That's called a reference case. And we've had in recent years, for example, references on same-sex marriage. You may recall that. And before that, on the right of Quebec to unilaterally secede from Canada, which was known as the secession reference. So this involves the government putting an important question to the court and saying, we need your answer on this issue. Very often, usually, questions of whether proposed legislation is constitutional or whether something, as in the case of the Quebec secession reference, whether a certain event, how it would be regulated under the Constitution. We decide about 85 cases a year, and around 20 or so, it varies from year to year, % of those involve the Charter of Rights and Freedoms that was adopted in 1982, 25 years ago. And the Charter cases attract the most public attention, even though they are only a portion of our work. The Charter, as you probably know, sets out the rights and freedoms that Canadians believe and have stated are essential to a free and democratic society. Freedom of expression, the right to democratic government, the right to live and seek employment anywhere in Canada, the legal rights of people accused of crimes, Aboriginal people's rights, the right to equality, For example, men, women, rights against discrimination on the basis of things like gender or race, the right to use either of Canada's official languages, the right of French and English linguistic minorities to education, the protection of Canada's multicultural heritage, and others. Under the Charter, the courts rule on whether the laws or government action comply if a citizen or a government brings such a question before them, either in the context of a dispute or in the context of a reference. And references, I should say, are quite rare. And I'm sure you're familiar with some of the decisions of the court under the Charter, but for example, the court held not too long ago that a school board's decision that a student could not come to school wearing a kirpan, this was a Sikh student, a religious object that resembles a dagger, unjustifiably breached the student's freedom of religion. In another case, the Supreme Court held a municipal bylaw that prohibited putting signs up on posters up in public space was unconstitutional as violating freedom of expression. The court has held many times that a search warrant is generally required for the police to conduct a search of a home or a person or a business. And the court has concluded that by, for example, denying a suspect the right to counsel, directly or indirectly, the police breached that right. And the Supreme Court has importantly confirmed basic Aboriginal rights to traditional practices, resources, and, in the absence of treaty, having settled this, to lands. In the 25 years since the Charter's introduction, deciding the charged issues that the courts have been obliged to tackle under the Charter has been a challenging one. It's not an easy job, but our Constitution requires judges to do this job, to be the arbiters of constitutional validity. And sometimes in the course of doing that job, we have to say that the law is inconsistent with the Charter. And when we say that under Section 52 of the Charter, the law becomes invalid to the extent of the inconsistency. So people say the court has struck down a law. In fact, we've ruled that it is inconsistent with the Charter to a greater or lesser extent, and then the Charter itself says, to that extent, that law cannot be upheld, because, of course, it is unconstitutional. It is void. In a democracy, let me conclude, all branches of government have a role to play. The legislature has the primary task of passing laws to address the needs and desires of society. The executive has the task of putting those laws into operation. And the judiciary, when called to do so, has a duty to ensure that the other branches of government comply with the law and the Constitution and to resolve disputes in a lawful manner. Together, these institutions make up a process that we call democracy. Thank you very much for listening so attentively, and now I look forward to your questions.
Thank you.